Hello, my name is Ian Jarvis, and I wanted to do a hopefully short video, I'm sure it will be, about the low traffic neighbourhood case in West Dulwich quite recently, judged by Mr. Tim Smith in the Royal Courts of Justice and announced to a great fanfare, which is great. It's really, really impressive and well done to everybody involved. The only thing is, I think we've missed a trick, and I want to get this out a little bit wider. So what can we most usefully learn from this West Dulwich case win, which was a group of residents in West Dulwich who took the council, which is Lambeth Council, to court over the imposition of a low traffic neighbourhood. So let's have a quick look, because there has been a little bit of, I'm sure, accidental misreporting on this. And again, I think we have missed in the major reports the most important bit. So let's look at a few facts. It was initiated by a group of people from a residents' association. So great. They got together and they very, very ably put together a package, a complaint, and eventually took their counsel to the High Court. But we mustn't be too pleased about the fact of having a low traffic neighbourhood quashed, because if you look on their Facebook page for that area, then you will see that many residents thought that a low traffic neighbourhood was a good idea. And really great, and they had traffic problems in their road, and since it had been in, some of those traffic problems had improved. It was also notable that some people on that Facebook group said it hadn't improved for them. I guess at the start here, I might say one really important thing. The issue seemed to be, in that area of London, a traffic problem. And I have to say that there are many ways that you can resolve a traffic problem. It doesn't have to be a low traffic neighbourhood. What's the difference between a traffic measurement, a traffic experiment, or traffic management, if you like, traffic management, that's the word for which I'm looking, and a low traffic neighbourhood? Well, it's actually very big. Traffic management could be, okay, we've got this problem, we want to improve the traffic flow. Well, why don't we make this street a one-way street in that direction and this street a one-way street in the other direction? It's another option. Whether it would have been applicable in that area, I've no idea whatsoever. I merely use this as an illustration that the first response to having a traffic flow problem should not be, let's put in a low traffic neighbourhood, because that means so many more things and is also very much more expensive, with cameras and all sorts of equipment that you've got to put in. And then if you decide it was not a success, it was not a good idea, then you would have to take all that equipment out. So what council is going to want to do that? Remember that point. Secondly, lots of other people in the area disagreed simply with bringing the case because of the costs it would mean to the council. Again, they have their perfectly valid point, and we must accept that there is no one way of thinking about these issues and around these problems, and people disagree. What we need to do is talk about it and work through potential solutions. So those are important points to make, and we need to recognize that and recognize the opinions of others, no matter how enthusiastic we are about our own particular solution. This is probably even more important. It wasn't a judicial review. Now, some of you may know what a judicial review is. I don't want to go in terms, but the first thing you have to do with a judicial review case is request a judge to give you permission to take it. Rather like an injunction, you have to put in a request to a judge, a district judge in the second case, for permission to go ahead with the court case. In this case, that was not what happened. It went straight to the High Court. We'll see why in a moment. But the point is, somebody said it was. And I was asked about this in a meeting that we were having, and I said, no, it wasn't a judicial review. And or even though it is reported in the local newspaper, it is not a judicial review. The person turned around to me and having gone to ask AI, and he came up with the answer which you see on the top left of your screen. And he said, well, AI says it was. So I repeated, no, it isn't. It was not a judicial review. And this gives us another insight in that once AI picks up something, that response that gave that person, it's a judicial review, will now be stored on the data that AI accesses. So next time somebody asks the same question, they're quite likely to get the same answer instead of the correct answer, which is, it was under the Road Traffic Regulation Act 1984. And that's the act that gives councils the opportunity of putting in traffic management measures, including low traffic neighbourhoods. And that's why it went straight to the High Court, because it was under that act, no need to ask for permission first. And this is why I always suggest that people read the judgment itself. It's freely available online, as all judgments are. And if you look at paragraphs 3 and 53, and there are one or two others where it says a similar thing, then you will see that is actually, according to the judgment, according to Tim Smith, who was the judge, that's why it was taken. And I'm sure if you ask anybody in that residents association, they will tell you as well. So it is always important when you read a newspaper, particularly about a court case or something which is really important to you, always go back to the source and find, in this case, the source, the two sources were possible. I didn't have the first, which would have been to contact somebody in the Residents Association and ask them. They would almost certainly have known, or at least some of them would. And the secondly, in this case, go to the judgment itself, which I had by that time downloaded and read and highlighted. Now, the important thing in this case is it was not specifically about the low traffic neighborhood itself, not whether a low traffic neighborhood is good, is in the right place, is a great idea, is a rubbish idea. That was not to do with it. What it was about was the consultation process. That's the important thing to notice. It was about the consultation. And one of the members of the Residents Association was the representative claimant, as they call it, this service station here. So hopefully his business will improve with this act. So what was it about the consultation? Well, it was brought on the basis of poor or inadequate consultation. You can read this in paragraph 28 of the judge's report, and that the consultation was in breach of something called the Gunning Principles. It's also known as the Sedley criteria, because Sedley was the judge who laid down, suggested even, those principles, those Gunning principles. Gunning was involved in the action, hence the name Gunning. And they've been case law. It is case law from a particular case involving those two people and more. Of course, Judge Hodgson was the head judge in the case, 1984-5 case. So a long time ago, this has been case law. When I discovered about the Gunning principles some years ago, when I say some years, only 3 or 4 years ago, I was struck by their simplicity. And lots of people, though, then said to me, no, Ian, nobody takes any notice of the Gunning Principles anymore. And even a lawyer said that to me, quite a senior lawyer, I understand, said that to me. And stupidly, I didn't follow it up further and stopped investigating. And I regret that seriously since then. But I guess we all make mistakes. I make lots of them. So what are the Gunning Principles? This was the particular case that laid down those Gunning Principles, and you can read about that in para 189. I've yet to get a full copy of that report, although I have seen the principles quoted, cited in many other cases. So there are 4 principles, as I said, very simply specified by Judge Sedley. He must have been quite a guy in his day. Is he alive? I have no idea at the moment. So the consultation must be at a time when the proposals are still at a formative stage. So there can be no predetermination that the council has already had a meeting, decided what it wants to do, and puts the consultation out to pretend it's consulting, but actually just wants to confirm its own decision. And you can often tell that when you read a consultation document, because it will be pointing the questions in the direction that they want to receive the answers, with no option to make any other suggestions, such as 2 one-way streets, for example, or a set of traffic lights, anything like that, or a zebra crossing, more parking. All those things could have been suggestions. I'm not saying they were appropriate in this case, but they could be suggestions for something else, for a similar event. So look out for anything that councillors have said, recordings of council meetings that you might have access to, even reports in a newspaper, although be careful, do make sure you get the facts right, to see if there is any idea that predetermination may be part of this. And it shouldn't wait, the consultation should not wait until after the decision has been made. You can have a consultation before the decision is made, and then you can have a consultation after. So you can do 2 consultations, and I think that was the case here, and I think in many low traffic neighbourhoods, and indeed in solar not farms, that can also happen. There can be a couple of consultations. Importantly, in this, the Judge Smith did comment on that and say that just because you know there's going to be a second consultation doesn't mean you can skip over parts of the first consultation. It still has to be done according to these 4 principles. So that's the first principle. The second principle, and says that the proposer must give sufficient reasons for any proposal to permit of intelligent consideration. Now, in one sense, that if you combine that with the first one, this really means that people have got to be given many different ways, or several different ways at least, of responding to that consultation. An online-only consultation breaches the Gunning Principles because it doesn't give people the equal opportunity to respond to that consultation. If you don't use a computer, you've never used a computer, you don't wish to use a computer, that's fine. You should be able to give your response to it and read them somewhere that's not on a computer, and also to input your suggestions and comments via another way, like a piece of paper, for example, even an email. So you should be able to respond to this by an email or by responding to the questions as you go through it. They should equally well be taken notice of. You've got to give sufficient reasons. So it's not not useful to say, we're just going to do this. You can comment about it. They need to give their thoughts. Whoever's consulting needs to give their thoughts about the pros, the cons, the pluses, the benefits, the disadvantages, the negatives about it. So you want to see an unbiased description of what you want to do. Now, that's quite difficult for many people to write because, of course, they're going to be, if somebody in the council who really thinks this is a great thing is not going to be the person to write this. It has got to be somebody else who, at the very least, even if they're part of it, can open their mind sufficiently to consider what other options might be. And indeed, one of the questions at least should be something to do with, how would you do this? How would you resolve this problem? Do you have some ideas you can put to the decision maker? That is also very, very important. So the third one is that time must be given for people to make considerations, to respond, to think about it, to take in that information that you have given them of the benefits and the disadvantages, etc. So they may have come across this just for the first time today, and if you've only got a week to do that, then that is insufficient. People are at work, people have families, so we have to take it in the context of normal people in normal time. Everybody is not working at their office and can take the time to say, oh, we've got a consultation, I'll work on it straight away, full time for the next week. No, people cannot do that. So there's got to be enough time. And that could mean it's got to be almost open-ended. There's got to be an allowance for extension to time. I believe in that way there often is, but again, it's limited. 12 weeks is a common one that is given by governments and local authorities as well. That may not be sufficient for some people, particularly if the notification that there is a consultation, there is a plan, there are some suggestions of what we're going to do. You as a resident in that town or city may not get the notification or the information maybe for a couple of weeks even, because of the way that it's been dealt with within the council. It took that time from, say, the request or the application to put in this low traffic neighbourhood and getting the information out to as many people as you can. So that's the first time that time has been mentioned. And in the fourth, it's mentioned again. Or it's implied again, if you like. The product of the consultation, i.e. the answers, the responses, the objections, the support statements, must be conscientiously taken into account by the decision maker or the decision maker's team in finalising any, and it says statutory proposals here, which was the case in the Gunning, but any proposals. I think we can interpret that more generally to mean any proposals that they make. So if I say, using my same example again, well, you could solve it by making X street a one-way street east to west and Y street a one-way street from west to east. And I would give some reasons why they could do that. I must be able to see in the final report where the decision is taken that that has been considered. You know, one of our residents, Mr. Jarvis, suggested blah, blah, blah. We looked into this and we decided against it or we decided for it. So you never know. So you've got to have not only that conscientiously, but they've got to provide you with evidence that they took it into account when considering that final decision. It doesn't mean to say that the individual decision maker has to read every single input to the consultation. That might be a very big task. If it is, then it's important that it should be taken. But certainly that decision maker should be given summaries, accurate, unbiased summaries of the comments so that they can use them and show that they've taken them into account. And the decision maker, if it is just one person, often it is, unfortunately, which I think is a very wrong thing. It's not democracy in my view. But if it is one person, then they should be able to say, I don't quite understand this. Can you send me the full details of this particular comment so I can look at it further? And they should be prepared to do that. Again, in many cases, the decision maker, particularly, I've been working in objections and planning applications for telecoms for a while, and they are very time constrained, 56 days from when the application goes in to when the decision has to be made. Now, I would argue that is totally against the Gunning principles. It's a breach of those principles to constrain it in such a way, and particularly with telecoms, such an important thing. So that's the essence of it. And Lord Brown, this is before the Gunning principles were made in 1984-5, in paragraph 62 of this particular judgment. Again, Tim Smith cited this in his report, and Lord Brown had said the reasons for the decision must be intelligible and adequate. So this means that the person who is put in, the person in the public, if you like, the people, should be able to see the final report as to why the judgment was made, or the decision was made by the decision maker or by the committee, and they must be able to understand why it was decided as it was, what conclusions were reached on the major or the principal important controversial issues. By this time, you will all know what are the controversial issues in your particular case, and disclose how any issue of law or fact was resolved. Now, that shows us also in 1953 that there were already by that time disputes on consultation. And maybe that's why Judge Sedley, he was a QC at the time, decided that it would be time to make those 4 statements that we've just been going through. And you see that they're not complicated words, they're very straightforward words, and yet they have so many implications that they form an excellent. One of the judges since then, who in a case, not this particular case, in another case, said, it's difficult to see how they could be improved in any way. So Sedley was right on the button. So the first, the winning argument, again, this is another important thing to know. It wasn't all singing, all dancing victory by the claimants, the Residents Association. And you'll notice I've highlighted that word unfair, because one of the unwritten things in Gunning, and that has been mentioned in many cases over the years, is it has to be fair. And that was why Gunning actually wrote those principles. And he said, in order for any consultation to be fair, it has to accord to these 4 principles. So it's quite good that the claimants in this case actually used that word unfair in their first ground, which was the one that, on which they won. So the ground 1 was that the council's consultation on the orders was unfair, and or that the council had regard to immaterial considerations when deciding to make the orders. I'm not going to go through grounds 2 and 3. I'm going to suggest that if you're interested, you read the judge's report. And I have put a link to that in a moment or two. I'm not going to give you everything. I want you to go and look so you can read that, please, that judgment. And this I found quite interesting because this was the number of fines and the appropriate amount of money that was gained in the months that the low traffic neighbourhood was in operation. Now, I find this a reason I find it quite interesting because, and I cannot say this definitely at all, could it be possible that one of the reasons for opting for a low traffic neighbourhood as opposed to a set of traffic lights or a zebra crossing or whatever it might have been was that it was going to make them some money? I wouldn't say that, of course, but I don't know. But it certainly, for a council to be thinking about the way of improving traffic management, it could be a perfectly legitimate additional benefit to them. We can actually make some money from this. It's going to cost us money to put it in place. So can we justify, we may make some money. It's not necessarily a bad reason for making a decision. Perfectly legitimate to consider it. So I want to give you a few links on this as well. So just to finish off with, you can find the judge's report. The judge was Tim Smith, and as you see here, he was sitting as a Deputy High Court judge in the Royal Courts of Justice straight away. So you can use that. All the reports of judgments and cases are stored on this. Some of the older ones are not. I say here, if you are considering, I'll have to correct that spelling when we close down. If you are considering addressing your counsel on this, and especially taking out a court case, whether it's a judicial review, which if it's for a planning application, it will almost certainly have to be. If it's something for which there is a different regulation or a different law, like as in this case, then it could be straight to the High Court. I strongly advise reading this in full and the following useful articles, which I give you and the links for on the next slide. So I hope you've got a copy of that. I will make this talk available on our website. And these are the 4 Gunning Principles. I just put them in there. I was doing a talk last Saturday, and I thought it'd be useful for people to take a picture of that with them all 4 written together. Let's just make this a little bit smaller. You don't really want to see me. There we go. So that is the 4 principles mentioned together. These are really good articles. I first read the Sheldon one when I found out about Gunning a few years ago. And what he and Gowling in particular do very well is they look at cases that have been taken under the Gunning Principles. They look at the issues and how the judge managed the procedure and the result, and why the judge made his or her decision in one way or the other. Some of them show where the claimant won, and some of them show where the government institution, whatever it was, won. But the important thing is that will tell you what you can do and what you might not be so wise to do. And these 2 papers do that very, very well, particularly the Sheldon one. A little bit old now. Sheldon was written in, again, another QC, written in 2012, and Gowling, which is a legal firm, and this was 3 of their particular specialist lawyers writing this, and that was 2013. Then we've got this Good Government paper with, again, it talks about what constitutes proper consultation, so it uses a few examples to go through that. And Landmark Chambers, again, they talk about, theirs is titled Legitimate Expectation. So everything isn't about law and regulation. If the council gives you legitimate expectation of they will do something, then if they don't do that, then you have a legitimate case to take up through this system with Gunning or similar. So, and again, we come across the name fairness. And these are documents that describe describe consultations. New Conversations 12 is on the Local Government Association website. Don't be too confused, because they put a paper out, or document, booklet out a few years ago, which was called New Conversations 2.0. And last time I looked, that was still up on their website. It's also still up on our website, and which is where I should put this. And it's highlighted with my highlights when I read it through a few years ago. Those bits are pretty much the same as they are in this version 12. So do go there, and you can still have a look at the old one on our website, which incidentally, I don't think I put anywhere in this talk, is ianjarvis.co.uk. This is a paper all over the government website. You will find lots of articles and things about consultation. Surprising that they don't make more of it in practice, but you would be very disappointed about that. So this will take you to that particular document, a 2018 document. It was the last issue, still in force, that particular one. And finally, the planning practice guidelines, which is a whole range of guidelines on all sorts of topics related to planning. And the 12th one down, if you follow it down, the 12th one is about consultation, which interestingly says that so far as planning is concerned, anyone, individual or group, can comment or object to any, I stress that, planning application anywhere in the country. So just remember that, particularly with, mention again, telecomms planning, or even low traffic neighborhoods, or solar not farms or wind farms. They have a national interest for all sorts of different reasons. So you can, if you live in St Ives, you can object to a solar farm, a solar not farm in East Anglia, say like the East Pye solar farm. So that gives you that guidance, that ability. So that's really great. And I think that's my last slide. But this is what I say too often. We can do something about it, but only if we do something about it. So that is my last comment to you, my last suggestion to you. Unless we get up our backsides, nothing will change. The reason I like it, again, yes, I'd forgotten about this this slide. This is a very unprofessional video. The Gunning principles apply anywhere there is consultation involved, and that includes voluntary consultation as well as statutory consultation. So again, solar, wind farm, BESS, net zero. I hope you noticed that. Emergency planning for anything, especially telecommunications, such as the masts. And another useful thing to look at is the Localism Act 2011. So don't forget that when you are considering what action you can take. We do have quite a lot of power in terms of our local authorities. Thanks for listening. Thanks for staying on for how long it's been. Unfortunately, my timer, I didn't switch it on properly, but that happens with technology sometimes, doesn't it? Even in Wimbledon. So good night, and I shall now close this down.